So I'm going to share this portion, something that Jackson specifically asked the judge in regards to the jury instructions, and this is the verdict form. This is what caused confusion. This is exactly where the jurors got hung up. And this is now what they're arguing about, claiming that she was acquitted. And that they're saying that the 4 jurors now, not including the alternate juror who first came forward, the 4 jurors have stated that they communicated that she was acquitted of second-degree murder and the leaving the scene of an accident or whatever crime. So she's acquitted of those charges. But so here's where things went wrong. So you remember the argument where she snapped at Karen Reed, something funny, you remember that? So it was about the verdict form, because she told Jackson, he's like, well, I've never seen this, and she's like, well, this is how we do it here. And then she asked Yannetti, you've seen this form before, because he practices regularly in the state of Massachusetts, and he said no, he's never seen it before. And then Karen kind of laughed. I don't know what she was laughing at, but so here's what Jackson requested that the judge. This is the hangnail that caused the problem. So watch what he's going to ask her specifically. He's going to ask her to give an all or nothing.
Thank you, Your Honor.
To give an all or nothing.
Yes. I
on the count 2.
Additional clarifying language. I would simply ask for one very simple amendment, and that is at the top of the verdict slip that says the 2 words, not guilty. We would ask that the verdict slip read, not guilty of the offense charged or any lesser included offense. That's it. And I think that and the court's clarifying instruction would satisfy the defense.
And the problem with that is this. In count 2, there are multiple offenses that they could have found her guilty of. And what should have been done, and this should be across the country, anytime there is a charge of which the defendant is to be found guilty or not guilty, there should be a choice for each and every offense, guilty or not guilty. And during their deliberations, if they all come to an agreement, especially when the judge says, you shall decide these things in descending order, which I'm getting ready to show you that she said just that. Okay, so now she's getting ready to tell this. They're going over the jury instructions that's going to be read to the jury. And so here is what she tells them. Okay, she's going with the prosecution and the attorneys that this is what's going to be read to the jury. So this was done outside the jury's presence, but this is how they were instructed specifically to go in descending order. So again, it should have been because they went in descending order. It's not like they just all went in there and just had a bunch of talk and said, well, I don't know what to find her guilty of. It was very specific that you start at the top, at least on count 2, and you work your way down. So once they have started on the first one, they should have acquitted her and then worked their way down. But they can't even get to count 2 until they've already acquitted her of second-degree murder. So this is count 2, what she says.
Have you here? I want to clarify my instructions regarding your verdict as to count 2 of the indictment. As I instructed you yesterday, there are 2 lesser offenses of that crime, which are involuntary manslaughter and motor vehicle homicide, felony, OUI, liquor, and negligence. Therefore, count 2 encompasses 3 separate charges, the most serious of which is manslaughter while operating a motor vehicle under the influence of liquor. In considering count 2, you should first focus on the crime of manslaughter while operating a motor vehicle under the influence of liquor, and if the Commonwealth has failed to prove that crime beyond a reasonable doubt, then you are to consider the remaining lesser included offenses in descending order. The lead charge is manslaughter while operating a motor vehicle under the influence of liquor. If you find that the Commonwealth has proved all 5 elements, or proven all 5 elements of this charge beyond a reasonable doubt, then your verdict shall be guilty of manslaughter while operating a motor vehicle under the influence of liquor. If, however, you find that the Commonwealth has not proven all 5 elements of manslaughter while operating a motor vehicle under the influence of liquor, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 3 elements of the lesser included offense of involuntary manslaughter. If the Commonwealth has proven the 3 elements of involuntary manslaughter, then your verdict shall be guilty on the lesser included offense of involuntary manslaughter. If, however, you find the Commonwealth has failed to prove beyond a reasonable doubt the crime of manslaughter while operating a motor vehicle under the influence of liquor and the lesser included offense of involuntary manslaughter, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, felony OUI, liquor, and negligence. If the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, then your verdict shall be guilty of the lesser included offense of motor vehicle homicide, OUI, liquor, and negligence. If, however, the Commonwealth has failed to prove beyond a reasonable doubt all elements of manslaughter while operating a motor vehicle under the influence of liquor, and has failed to prove all of the elements of the lesser included offenses of involuntary manslaughter or motor vehicle homicide, felony, OUI, liquor, and negligence, then your verdict must be not guilty to count 2.
Okay, so do you see the problem here? In count 2, there are multiple charges of which she could be found guilty for. And Jackson asked it to be an all or nothing verdict. So, in each and every charge, which has a different sentence depending on which one they chose, just lumping all of those in one count, each and every offense that they had to choose from should have had a guilty or not guilty box next to it. Because by not doing that, you are preventing their acquittal. If they cannot, she specifically says in descending order. So when you start at the top and you say, okay, well, do you see what I'm saying? She said start at the top and then find guilty or not guilty and then work your way down. So each charge should have guilty or not guilty. Each and every one. And Jackson's not arguing this. Yanetti's not arguing this. And you saw what he asked for. He said, please put the box that she's not guilty of second degree or not guilty. I'll play it again.
One very simple amendment, and that is at the top of the verdict slip, it says the 2 words, not guilty. We would ask that the verdict slip read, not guilty of the offense charge or any lesser included offense. That's it. And I think that and the court's clarifying instruction.
So this was after they had their big argument and she snapped at Karen over the verdict form because it just was ridiculous. And it was still ridiculous though because he's asking for an all or nothing not guilty. And again, each and every, what he should have asked for was for each offense that she can be found guilty or not guilty for, there should be a guilty or not guilty box. I mean, what do you think? Is that not a reasonable thing to ask for? So now the 4 jurors have come forward, and he's asking for a motion to dismiss or in the alternative, an evidentiary hearing. Okay, so you have 4 jurors, and there's some statements that are stating that they did not know how, the thing that is allegedly was said was, how do we let the judge know that we've acquitted her of this? So when they presented that to the jury foreperson, it was the jury, if that's what was actually said, it was that jury foreperson's duty to go to the judge and say, we have a question. Because he was given the position and the responsibility of communicating to the judge for the jury. Okay, so they, according to what's being alleged, had questions. And those questions were not communicated to the judge. Or if they were, this man right here and their defense lawyers was not allowed to review any of the communications. And so that's a problem, and I've shared cases from the Supreme Court of Massachusetts and from the United States Supreme Court have stated, and I have a video with cases, links to cases in the description, okay? Because if you're going to talk about something, you need to, have the cases, right? So there was a case where a judge refused to share the communications from the jurors to the defense lawyers. And so they that was rejected. That was a big no-no. Judges shouldn't do that. But for whatever reason, she did not share the communications, that she just read them out loud. And there was, I believe, one communication, there was I think 3 or 4 notes altogether, and one of them stated that they were stuck on one of the lesser offenses. So, at any rate, any charge that a defendant is being charged with and you have a trial, who in their right mind would disagree that for every offense that they have to evaluate guilt or non-guilt, there should be a guilty or not guilty box? It shouldn't be an all or nothing. No, 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 no. For every single offense. For every single one. And in case people didn't know, I know everybody's heard about this case, and it's about her running him over with a car. Did you know that in the end, while nothing was presented in this 10-week trial or 8-week trial, whatever, nothing was presented about her beating him to death. But what was read to the jurors for the second-degree murder, even though the booking officer described the second-degree murder as vehicular homicide, the second-degree murder was she beat him to death. He completely changed his story. Okay. Anyways, I just thought I would mention that. So what do you think? Do you think that for each offense there should be a guilty or not guilty next to it? I mean, why? Why would there not be? What is really happening?